Hello. Thank you for registering and joining us today for the first session of 2023's Legal Strategies for Women Leaders. My name is Mindy Johnson. I'm an attorney here at Foster Swift and co-leader of our firm's Business Tax Practice Group. As you may know, the idea for this program developed during a lunch meeting of several Foster Swift women attorneys. The discussion uncovered that many of the firm's female business clients are increasingly busy and may appreciate focused discussions of specific legal issues that affect them directly. This is the second year of our program. Topics that we've covered last year included women-owned business certification, non-qualified deferred compensation for women executives, protecting your business assets during divorce, and estate and succession planning for female leaders. Recordings of these sessions can be found on our website at www.fosterswift.com. A primary purpose of these programs is to educate attendees and emphasize that it's not up to one person to ensure the success of a business. Instead, it takes a team of different professionals to get the work done and help a business to thrive. To that point, today's program is informational and not legal advice. This is our first of 4 sessions scheduled for this year. Each session will provide ample time for participants to ask questions, discuss legal opportunities, and problem-solve challenges that women leaders face. If you have questions, please use the Q&A feature. This session is being recorded, and we will email you a link following the program, along with answers to any questions that we did not have time to address today. We want to be respectful of your time, so we will limit the session to 30 minutes. In today's discussion, we'll hear from attorney Emily Wisniewski. Emily is a business and tax attorney in our Lansing office who also has a master's degree in business administration. This enables her to provide not only legal advice to her clients, but also practical business solutions. One part of Emily's practice focuses on intellectual property, and she'll be speaking today about the importance of protecting your brand. Emily, thank you for joining us.
Thank you so much for having me today.
What do you think? Should we get started?
I think that'd be perfect.
Great. Well, let's dive right in. So like many legal issues, the concept of intellectual property may have its own technical jargon and language. So can you tell us in basic terms, what is intellectual property?
Yeah, of course. So intellectual property is kind of an umbrella term. And it's a term that's used to refer to intangibles that are subject to ownership and other rights. These often refer to things that are creations of the mind, literary and artistic works, designs, symbols. Basically, intellectual property comes along with its own set of rights. And these rights can give the creator of the intellectual property exclusive rights over the use or reproduction of their works. One other way that we'll often commonly refer to it is IP. So if you hear someone talking about IP, that's just the shortened version of intellectual property.
What are the main types of intellectual property? You've thrown out a couple of terms, but are there basic categories we should know about?
Yeah, there's 4 main categories that we usually kind of divide things into. So it's patents, copyrights, trademarks, and trade secrets. I'm going to explain a little bit more about each. So patents they basically protect inventions. So there's 3 main categories that in the US that we recognize. They're design patents, which apply to new, original, and ornamental designs of manufactured articles. Utility patents, which apply to useful inventions that are novel and non-obvious. And this can include processes, machines, goods, chemicals, biological, and other compositions of matter, and any improvements to those categories. And then the third category is actually called plant patents, and that's actually my favorite category because it applies to distinct and new varieties of plants, which I think is really cool. For ownership of patents, usually the ownership rests with the inventor or inventors, and the Patent Act actually requires the inventor or inventors to be an individual. As far as copyright goes, these cover original works of intellectual and artistic expression. So this can be books, photographs, movies, music, software programs, websites, paintings, sculptures, any type of thing that you are creating can usually be covered by a copyright. The one requirement that you can't actually copyright an idea. Again, ownership is going to vest with the author, or if it's a work made for hire, it could vest with the employer. But one of the most important things is it also must be a human again. And this has been really important in the new world of artificial intelligence, because this has been a pretty wide debate over whether AI could actually own a copyright or not. The next category is trademarks, and they're used to identify or distinguish a particular source or origin of goods or services in a relevant marketplace. And these range from logos, sounds, words, colors, symbols, jingles, basically anything that you can use as a company to distinguish your service or products. That's going to be a trademark. There's two categories that are kind of tossed around in there, and they're called trademarks and service marks. You probably have heard those words used before. So trademarks generally cover goods and service marks generally cover services, but most people just kind of use the word trademark interchangeably, or they'll just say marks for short. And the nice thing is trademarks can cover many products or services. And as far as ownership of that, it usually vests with whoever the applicant of the trademark is. And finally, the last category is trade secret. So trade secrets can be protected both at the federal level and then by most states. I think there's literally one state that doesn't have a Trade Secret Act. And trade secrets apply broadly to business, financial, and technical information. This could be like your marketing plan, your pricing, discount structures, chemical formula, software source code. So in order for something to be a trade secret, there's 3 requirements. So information cannot be generally known or ascertainable outside your organization's control. You have to derive independent economic value from that information, and you're making reasonable efforts to preserve its secrecy. So one of the most famous examples of a trade secret is supposed to be this KFC famous recipe for their chicken, okay? So the owners supposedly keep this chicken recipe in a vault where only 3 people have access to this vault. And so you can see that they're actually taking all the efforts to maintain its secrecy. Only a few people know about it. They're actually keeping it in the vault. And finally, obviously, they're getting value from it because KFC chicken, it's delicious.
So I appreciate where you're coming from with the trade secrets, but not a lot of my business clients have that type of intellectual property to protect. One of the things I most often hear about are those trademarks or service marks, and really they boil down to branding of the company. So what can a particular company do to protect this trademark?
Yeah, there's several main things that you can do. So one of the nice things about trademarks is you actually get certain rights through common law. So as long as you are using your mark in the United States, you're automatically going to get some type of protection. So you'll get protection in the geographic area in which you use it. Generally, though, most people want to expand, and especially with like the global marketplace that we have, it's very hard to figure out where you're just using it. Are you really just using it in the city of Lansing, or are you making online sales, to Delaware, to Florida? So generally, we recommend that people register their marks. I'll talk a little bit more about where you can file for registration, but one of the best things that you can do is you can register your trademark. The process is relatively inexpensive. It's, somewhat time consuming just because USPTO has been taking, up to 9 months right now to review applications. But recently I went to a conference and they said that process is going to be sped up. So I fingers crossed. So that's one of the first things that you can do. You also need to keep using your mark. So the way that you gather rights in your trademark is through use. So you can't, pick a tagline, use that tagline for a month and then abandon it. And then 5 years later, when someone's using a similar tagline, you're not going to be able to enforce rights against them because you haven't been continually using it. So make sure you're using your mark. If you have any kind of what we call a design mark, so like your logo, make sure you're using your logo in the same form. Because if you, added elements to it or taken things away, that's not in the same form. So you've not been continuously using it. One of the nice things that you can do is you can put notice requirements on your different trademarks. So if you don't have any type of registration, you can put the little TM symbol. I'm sure you've all seen it. There's a little TM symbol that goes in subscript that can go by your trademarks, or you can do an SM symbol by your service mark. Or if you do have a registration, there's a little R that's in a circle. We call it the R ball symbol. And so you can put that by any of your registered marks. And that's really nice because that lets other competitors know, hey, this is my brand. I'm protecting this and I have a registered mark for this symbol. Finally, the last part of this is you want to police your marks. So that doesn't mean that you have to go out in the workplace and track down everyone who is potentially infringing your mark. But if you find another user who has a similar mark, you know, if it's confusing to your consumers, you might want to send them a cease and desist, and you might want to look at different legal action because you don't want to confuse your consumers, and you also have a duty to make sure that your mark remains a symbol that is branding your particular.
I'm glad that you mentioned that at the end, because that's what I see the strongest benefit of having protection for your intellectual property is being able to really enforce your brand and make sure that no one can infringe on your right and take advantage of the goodwill that you've generated through years and years of your business just by taking a logo or stealing a tagline. So it's really helpful. I'd also like to just get your insight too about copyrights. We talked about trademarks and what can be done to protect those, but with that literary material or written copy, I know a number of clients want to make sure that that's protected. So how do you protect a copyright?
Yeah. So as far as registration of a copyright, again, you don't need to have it. As soon as you have your copyright, your material fixed in a tangible format, you automatically are getting protection. However, weirdly in the United States, in order to enforce that protection, you actually do have to have a registration with the US. So again, this is not a super time-consuming process. It's actually fairly cheap. Usually you hear back from the Copyright Office within about 2 months of your application. And you, as far as ownership, you're really going to want to make sure that you are clear in everything on your application so you don't run into any issues, because that's where I see the most back and forth in the Copyright Office. You don't really have to do a lot of maintenance to maintain your registration. Actually, there's none after 1978. They're going to be creating your work after then. And the nice thing about copyrights is you don't actually have to take any actions to enforce. So unlike trademarks, you're not required to police copyright. So you don't have to go after every Tom, Dick, and Harry that is potentially infringing your work. Although I'd recommend it just again to keep your work, unique and keep your work strong. But you don't have to actually go after all those people. And then there's also different notices that you can put on your work as well. So the general one that we see is it says copyright with a C, also in a little ball. And then you can have your name of the author of the work. And the nice thing about that notice is you can put that on any type of work that you have created. You don't actually have to have a registration after that work.
Well, let's say a client did want to seek registration for copyright protection. What are the steps that they would follow to do that? Am I correct in assuming that a call to you would be that first step?
That would be great. So obviously clients can go through us, they can do it on their own. The nice thing is that we have done this process a lot of times. So often I will have clients that start an application themselves and then they call us because they're like, I don't know what these questions are. So in general, for the steps for trademark protection, what happens is we first start with a clearance search. So we will review the Federal Register usually, and then we kind of do a couple other common law searches to see if there's any marks that would be considered confusingly similar, because that could block your mark from getting a registration. And then we'll just, in general, give you advice on whether the mark is actually going to be able to distinguish the source of goods and services. So something that we run into a problem with a lot is something called descriptive marks. And descriptive marks essentially describe the goods and services being offered. So if I was to go sell blazers and I sold it under Emily's Brown Blazer Company, that's descriptive of what I'm offering. And that's not really fair to any of the other people that also want to sell brown blazers under that mark. So, we'd advise you, hey, maybe find something that's a little bit more unique. One of the examples of like a super unique mark would be like Xerox. That was a made up word, and that was used to distinguish, obviously, the brand Xerox. And so we recommend people go with something that's more distinctive. The next step is obviously you file an application. And then, as I mentioned before, if we're filing an application with the USPTO, it can take a while. So it's going to take about 9 months for them to review the application. They might come back with a few additional questions. And then if nothing happens, then the application will be approved for publication. And then in 2 months after that, we get a registration certificate. After you have your registration certificate, usually you have to still do certain different filings. So between the 5th and 6th year, we have to file a declaration of use that says, hey, we're still using this. And then you have to do that again every 10 years. And the reason behind that is because for trademarks, your protection can last indefinitely. So you could hold a trademark for hundreds of years as long as you are continuing to use it and continuing to pay those filings.
So you had mentioned with the trademark registration, there's a publication. So I assume it's an opportunity for other people to come forward and say, no, that company should not be using that mark because I'm using it. Is that a possibility?
Yeah, it's a definite possibility. We've had it happen before. It is, I will say in general, it is more rare because usually the USPTO does a pretty good job of determining whether or not another mark is going to have, again, that buzzword likelihood of confusion with your mark. However, again, the publication period is 30 days and it's published in what's called like the official gazette. And during that time, people can object. It's important to remember that people can also object after your publication. So if they object during that time period, it's called an opposition. But if they object after that time period, it's called a cancellation. So people can apply to cancel your mark for a variety of reasons. One of them is non-use. So if you stop using your mark, good luck. Another one would be if your mark becomes what they call generic. So for example, Kleenex is used to refer to tissue paper, right? And then everyone started referring to tissue paper exclusively by the name Kleenex until they essentially lost a lot of their brand protection because it became the generic term to refer to all tissue paper. So you want to be very careful to avoid that as well.
So after you've attained trademark registration, does that mean that you have the assurance that no one will sue you because they are contesting your right to use that mark? Or what is the extent of the protection that's provided there?
No, so there is a whole bunch of people that could still sue you. So really the nice thing about having a registration is it just gives you certain presumed rights. So they can say, hey, based on this registration, we actually know this is your first date of use, and you can point to the registration for certain things. But that doesn't mean that other people haven't also been using the mark during this time. You could have a company that's had the same or a similar mark for longer than you, but they have only been using it in a certain limited location. Or, again, there could be someone else that has a registration on the register and it's very similar to your mark, but it's not, completely identical. So it wasn't picked up in the USPTO search and it also wasn't picked up during the opposition period. But later on, they might come in and say, hey, we've actually now realized that your mark is very similar to ours. And so we're going to come after you at this time period. So no, there's definitely no guarantee for a registration that people aren't going to come and see you, but it's one of the good defenses that you have is again, presumed certain rights.
And so if someone does come forward and contest your registration or sue your company after you've registered, can you help prepare a defense for that?
Yes, we can definitely help prepare a defense for that. That's one of the things that we can help do.
So Emily is the #1 call for all trademark and copyright protection questions. Good to know. So we've talked about the trademark protection and registration. Is there a difference between that and copyright registration?
Yeah, so the copyright registration is with a different office. So trademark is with the USPTO. Copyright is going to be with the US Copyright Office. And it's just a much simpler process. Like I said, it's only a few months. And the nice thing is usually beforehand, We can run a search, but it's not really necessary to do so, because the nice thing with the copyright is you are protecting something that you have created yourself with. So as long as you didn't steal that idea from someone else, we should be able to get copyright protection for that, as long as it falls, one of the categories makes sense. So again, a much simpler process, a lot easier.
Let's move back to that idea about trade secrets and the KFC secret spice recipe. So let's say a client or a company of ours does have a trade secret and wants to protect it. What are the steps that can be taken in order to obtain that protection?
Yeah, so the weird thing about trade secrets is you don't actually register them anywhere. So a lot of the other things that we've been talking about have been required to be registered at the various offices, or even if they're not required, we're highly advising it. So trade secrets are different because even if it's a secret, you're not telling a lot of people about it. You want it to, remain as confidential as possible. So what we recommend for companies is 2 things. So first of all, you're going to want to clearly identify what is actually going to be protected. So you don't need to make everything a trade secret. If a lot of people know your top 10 clients, it doesn't make sense to keep those clients a secret. Like, that's already well-known information, and what kind of other competitive advantage are you gaining from that? Second of all, you're going to want to provide some kind of adequate security. So that doesn't mean you have to have a top secret vault. It does mean, though, that you might want to have special passwords, or you might want to have, a security guard on weekends or something like that, or you might want to have locked doors in the offices. It doesn't have to be huge steps. It depends on the value of the information as well. So, kind of keep in mind that that's sort of proportional. You're going to want to monitor where the information is stored and limit who actually has access. So, if you have an intern coming in, does the intern actually need to know, all of your client pricing? Maybe not, though, if that's going to be something more secretive. So you're going to want to be like, okay, I'm going to store this in certain parts of the computer, and maybe this is only password protected, and only 10 people have this password. You're also going to want to enter into different confidentiality and non-disclosure agreements. So you're going to want to do those for both your employees and for the people that you're working with. So outside vendors or other partners. And finally, you're going to want to provide training and inform your workers. So your workers aren't going to take steps to protect your information unless they know what they're doing. If they don't have any idea what they're doing, they're just not going to take those additional steps, and they're not going to realize the value of protecting this information.
I like the fact that you reference non-disclosure agreements and confidentiality agreements. Those are routine legal documents that we draft on behalf of our clients in many contexts, when starting with new customers, suppliers, when engaging in a merger or acquisition. Are you the go-to person to help with those sorts of things too?
I am one of many people at Foster-Sift that can help with those things. We have an entire team. I'm always happy to help, but like you said, it is a very routine document that we do. So if you obviously contact anyone in the business practice or business and tax group, we will be happy to help with that.
Wonderful. Let's see if we have any questions from the audience. Any of the attendees, you're welcome to ask questions. We have just a few minutes. If you have any follow-up burning questions or comments to share with Emily, you're welcome to do that now. We'll continue to monitor that, but Emily, thank you for your expertise and willingness to share it with our group today. We always appreciate that practical guidance that's provided by our business leaders, who also happen to be women professionals. So I also would like to thank all of you for attending this session of Legal Strategies for Women Leaders. As mentioned, we'll be sending a link to today's recording, as well as a short survey to all attendees. We do value your feedback and look forward to providing you with valuable programming throughout the year. Additional scheduled topics for the remainder of 2023 include internet reputation issues, employee handbook considerations, and what to do if you get sued. We'll have additional information about dates and speakers on those topics within the next few weeks. So as we wrap up our session today, the screen should be showing a list of the firm's women's attorneys and their areas of practice and contact information. If not, that information can be found at fosterswift.com. And as women professionals, we always value the opportunity to network and do business with other women leaders. So please consider this an open invitation to reach out and connect with any of us. Thank you for joining us again today. We look forward to seeing you at our next session.